Hello, everyone. Welcome to another lecture on dealings in land in Malaysia. Today, we're going to look at the parties. Who are the parties who are involved in a sale and purchase transaction in Malaysia? We can start with the first as someone holding a power of attorney document to deal with with a particular piece of land. However, it has to be a valid power of attorney. The document would have to have the seal of the court before it can constitute a valid power of attorney. If he should just use a document that does not have the seal of the court, then any transaction that is carried out may become a nullity under the provisions of Section 340, subsection 2 of the National Land Code. In the case of Magnum Finance and Ling Ping, the court set this out clearly. When construing a power of attorney, general words may need to be viewed in the light of the stated objects of the power of attorney. The stated objects have to be specified clearly, and in this case, the stated objects were clearly outlined in the recitals, limiting the exercise of Ban's powers in carrying out the terms and conditions of the agreement. In other words, there is a limit to the power of attorney. It cannot be that the power of attorney is a complete free for all. You may also be an agent, but for an agent to act on behalf of the principal, it's important that the agent shall have express authority. In the case of Chew Hock San and Connaught Housing Development, the official booking for the shophouses had not commenced. There was no notice, nothing to say that the booking had commenced. But a clerk accepted checks and issued written receipts. Now, this clerk could have been acting in good faith. He just wanted to help people. But the official booking had not yet come into the open. It has not yet been advertised. So, and it's normal that until you advertise and you say that there is a soft launch or booking is going to start, the people at the counters who are entitled or who are allowed to accept checks, only then would they be allowed to accept checks and bind the principal, i.e., to bind the housing developer. But not in this case. The clerk at that time did not have the authority to collect the checks, and therefore neither was there any representation by the developer that the clerk was authorized to accept bookings on his behalf. Hence the decision that whatever the clerk did not bind the principal. Let's look at an administrator of an estate. Under Section 60 and 71 of the Probate and Administration Act 1959, an administrator of an estate has to obtain leave of court. After getting the leave of the court, only then can he enter into any transactions. But at the same time, assuming if he does not get the leave of court but still proceeds with the transaction, but there is an interested party who wants to challenge this, it's quite it's quite difficult to say that the action or the agreement has now become null and void because there is an interested party in the picture. So do refer to the case of Chi Hock Lai and see how the court came to this particular decision. As a registered chargee, the person steps into the shoes of a vendor. All right. Now, why do I say that? Because under the National Land Code, a chargee takes over the position of holding, he has given the charge and he has a title as collateral. But he still does not become the owner of the land. He's still a chargee. But the minute it is registered, he becomes what you call a registered chargee. And as a registered chargee, since he has given the money based on this collateral and there is a default in the repayment, all the steps have been complied with, asking the chargeur to pay up to satisfy the loan, but nothing has been done. So he then has what you call an indefeasibility of the charge. And with that, he may then go ahead and apply for an order for sale of the said land from the court to satisfy his debt. For further details on what happens, please look at Section 259, subsection 3 of the National Land Code. This particular section puts down, subsection rather, states the procedure at the sale. It has to be done with the presence of a court officer and not anyone else. And then once the auction starts and the parties have, make their bids, the court officer has the right to declare the sale concluded in favor of the highest bidder. Then the purchaser at the sale is entitled to get a certificate of sale, which he will then use to register himself as the owner. So the bank has now the bank that gave the charge, i.e. the chargee, i.e. the chargee bank, is now in the position of a vendor because the owner of the land had defaulted. So this is the procedure. Finally, we look at a beneficiary as a party to the transaction. A beneficiary of a deceased estate. Okay, you think that fine. Um, okay, I'm a beneficiary. I have an interest in part of the land, assuming there are 6 of us. So we have 6 plots of undivided shares. We are all entitled to the undivided shares. We are all entitled finally to be registered as owners of the undivided shares. But until the administration of the estate is complete, we cannot hold ourselves out as the title holders or the registered holders. Not yet. The administration of the estate has to be complete. Once the administration is complete, then the person has a right to his interest in the land. While one may decide to sell, he can sell part of his undivided share to another purchaser, somebody who is willing to now take over 1/6 of the land together with the other purchasers. But until then, he does not have a right. So that is all for parties in a sale and purchase transaction. Thank you very much. Hope you've enjoyed the lecture. See you at the next topic. Thank you.